Okay, in this video we're going to go over vacating a default judgment. So this might be of interest to you if you have a default judgment from maybe getting a credit card loss related lawsuit and not responding to it at all or in time, or a private lawsuit with any other individual or person, and you just did not respond to it. Um, Sometimes just Googling, you can find some really good information, or you could, ask around and, get competent legal advice from a lawyer, or you could just, ask people who study the law that know what they're talking about as well. So we're just going to read this. We're going to learn a little bit. We're going to throw this up here, encouraging people who maybe are on YouTube or elsewhere to learn for themselves and take the matter possibly into your own hands of at least learning about how you can easily vacate a default judgment. Um, if your IQ is up and you're halfway intelligent, you don't need to hire an attorney, in my opinion. So anyways, um, vacating a default judgment, order to show cause. This guide provides general information for New Yorkers who are facing debt collection lawsuits in the New York City civil courts. It does not apply to courts outside the state of New York. It is not a substitute for obtaining legal advice in your individual case. Okay, so if this was one of the first things I clicked on when I Googled vacating a default judgment. So if you Google vacating default judgment, you can get similar. You might want to type in vacating default judgment, Illinois, vacating default judgment, Ohio, vacating default judgment, California, and make sure that what you start reading is specific to your specific state, and then check at the county clerk's website in your state, or if it's a federal case, look up vacating a default judgment, federal court. So they're all got the same principles, but I'm just going to read this one because it was one of the easiest, shortest to the point sites that came up. And it allows me to zoom in on the screen so that I can make it very visible to you. So again, same principles are going to apply. The details might be different. Read around, make sure you find the right information. What is a judgment? A judgment is the court's written final decision in the case. If the judgment is against you, it will state how much money you owe to the plaintiff. What is a judgment creditor? A, quote, judgment creditor is a creditor or debt buyer that has obtained a judgment against a defendant. What is a default judgment? When a defendant fails to appear in court or defaults, the court will issue a judgment against the defendant. A judgment issued under those circumstances is commonly known as a default judgment. The court usually awards the plaintiff the amount demanded in the complaint plus interest and court costs. The court usually does not award attorney's fees on a default judgment, but it may do so. Okay? The court usually awards the plaintiff the amount demanded in the complaint plus interest and court costs. Okay. They're issuing an order. Whoa. They're issuing an order, but that doesn't mean that the judgment creditor actually gets the money. It's just a judgment. It's out there. It doesn't necessarily mean that they ever are going to get the money unless they go to enforce the judgment. Okay? So in some states, they have to actually execute on the judgment and then issue that execution order to the sheriff in the county that the debtor is at, and they can attach that to any property. They can put a lien at the county recorder against any property if it was a collateralized debt, and if it's a non-collateralized debt, like just a credit card or whatnot, usually they can only attach that to your wages or a lien or excuse me, a levy on your bank account. So you want to be careful that if you have had any lawsuits that have gone into default judgment or any kind of judgment, obviously, I'm not trying to get anybody to avoid paying a judgment, but obviously it would behoove you not to keep, tons of money in your bank account if you have potential legal, lawsuits and things coming up. Okay. Um, let's see. As well as with wherever you're working, independent contractor, employer, so on and so forth. Definitely get some competent information on preventing your wages from being garnished. I know that you can more and more employers as Bitcoin is increasing in popularity. Um, More and more employers are accepting the option of paying their employees in Bitcoin, which is a big problem for people that want to garnish your wages. But you know, so be it. So make sure that you keep tabs on Bitcoin. Once or twice a day, I always go to Google and type in Bitcoin and see what's going on in the news and see what's going on in the web searches. And it's pretty interesting things. You can click the exchange rate. One Bitcoin is now $720.90. Up, just went down $1. So it just went up 90 cents. And this is also for Litecoin. One Litecoin is $11.66. One pure coin is $2.36, and one Dogecoin is 0.5982 US dollars. So, just some interesting things to keep track of Bitcoin. We actually, before I go more into this default judgment thing, at understandcontractlawandyouvin.com, we do offer coaching consultations about Bitcoin, and we're going to be putting more and more of our website attention on Bitcoin. There's a link here where you can sign up to accept Bitcoin and to have a Bitcoin account and a Bitcoin wallet. And then there's a link below where you can actually get a Bitcoin debit card. So yes, you can pay for groceries, gas, and all the other daily expenses with Bitcoin. Okay? So I don't want to hear the excuse, I need to use Federal Reserve notes. I need to support the Federal Reserve System. I need to support the enemy. I don't want to call them the enemy, but you're going to support the status quo because you need Federal Reserve notes to buy groceries and gas and things like that. Well, it's not true anymore. You can get a Bitcoin debit card, and you can get payments from your employer in Bitcoin. Okay, and you can send and receive payments from your family, friends, online merchants, and elsewhere with Bitcoin. So look into that. We have coaching consultations down here. You can call the number. You can pay for a consultation in Bitcoin or in PayPal with any credit or debit card. You do not need a PayPal account. And you can talk with us about Bitcoin, and we can give you some knowledge and information about Bitcoin or anything else, any other questions you have based on any of the other information that you find on our website. Okay, back to the judgment thing. Judgment. When a defendant fails to appear in court or defaults, the court will issue a judgment against the defendant. A judgment issued under those circumstances is commonly known as a default judgment. The court usually awards the plaintiff the amount demanded in the complaint plus interest and court costs. Okay, we went over that already. Can I reopen a default judgment? Yes. Under certain circumstances, it is possible to vacate or reopen a default judgment. The court has a special procedure for determining whether to vacate a default judgment. The procedure is relatively simple, and most pro se defendants can navigate it successfully. What are the criteria for vacating a default judgment? There are two main reasons that a court will vacate a default judgment. One, excusable default, and two, lack of personal jurisdiction. These reasons are explained below. Excusable default. Excusable default is the most common reason for vacating a default judgment. It has two parts: a reasonable excuse for missing the original court date, a meritorious defense or good defense. This is a time limit for moving to vacate a judgment because of excusable default. 1 year from the date you were served with a copy of the judgment. Oh, there is a time limit for moving to vacate a judgment because of excusable default. 1 year from the date you were served with a copy of the judgment. If you were never served with a copy of the judgment, your 1 year clock has not started. Okay, so once they send you a copy of the judgment, you have 1 year to move to vacate it based on excusable default, meaning a reasonable excuse for missing the original court date. Common examples of reasonable excuse. The most common example of reasonable excuse is that you did not receive a summons telling you to come to court. That happens quite often, believe it or not. Other reasonable excuses are that the time you received the summons you were out of town, ill, incarcerated, unable to take time off from work, or that you could not answer the summons for some other good reason. You would also have a reasonable excuse if, in response to the summons, you telephoned the attorneys to the plaintiff and they told you not to bother going to court. Sometimes people do not respond to the summons because they do not understand what it is. This is not normally considered to be a reasonable excuse, however, some judges will accept it. You all know what a summons looks like. Come on, it's, in the so-and-so, here's a sample of a, no, it's not. It's really hard to find an example of a summons within 30 seconds by going to Google. Civil summons. It's not helping us out here. You know what a summons looks like. It says summons on it. It looks kind of like, it looks like this. Let's see. Looks like this. Okay, there's not. Okay, there you go. That's what a summons looks like. In the so-and-so, it's got a header. It says in the so-and-so district court of whatever, for the such and such county, such and such state division. Plaintiff versus defendant, case number. Try to get this a little bit larger. Full screen. There you go. Not exactly going to be styled like this, but you're going to see in the such and such district, superior court, appellate court, whatever, of the such and such county, such and such state, such and such division. It's going to have the name typed or written for the plaintiff and versus defendant, case number so-and-so, and then it's going to say here summons. This is actually not a summons. This is an answer to complaint and civil summons. Okay. But it's going to have this header on it, and then it's just going to say summons here. What about this one? Juror summons sample? No. If you get a document that has plaintiff and defendant and a case number at the top, like I just showed you, and then it says summons, okay, that's a summons. It's requiring you to make an appearance and giving you an opportunity to defend your case in court. Let's go back to this. Sometimes people don't respond to the summons because they do not understand what it is. It clearly tells you what it is. I can also, here's another kind of a sample summons that we have here. Here we go, in the International Commercial Court, blah, 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 summons, case number, so-and-so. And it'll tell you in a quick paragraph, an international adjudicatory action has been filed against you in the International Commercial Court. You have 20 days after the summons is served and you need to file a written response to the attached petition with the Secretary of the Court at the address given below. Phone call will not protect you. Your written response is required, blah, blah, blah. If you do not file your response in time, you may lose the case. Your rights, titles, and interests may be affected without further warning from this court. Court rules are available at blah, blah, blah. Okay, so, it's kind of silly for people to not know, that they have to act, and what it is, but, anyways, that website was talking about it. Sometimes people do not understand what the summons is. I don't know how that could happen, but common examples of a meritorious defense. A defense is a reason why you don't owe the money, not a reason why you can't pay. For example, if you would like to use the defense of identity theft, you would write, "This is not my debt, I'm a victim of identity theft." For a list of possible defenses, see common defenses to debt collection lawsuits. Interesting. If you don't know what else to write, most people can honestly state, I dispute the amount of the debt. Disputing the amount of the debt combined with improper service is a sufficient, very common reason for the court to grant an order to show cause. Lack of personal jurisdiction, improper service. The court can also vacate a judgment if you were not properly served with a summons. Look here for an explanation of New York's rules of service, including some common examples of improper service. There are advantages and disadvantages of trying to vacate a judgment on the grounds of improper service. The main advantage is that there is no time limit to seeking to vacate a judgment on the grounds of lack of jurisdiction. Also, if you seek to vacate a judgment because of improper service, you do not need to cite a meritorious defense or any defense. The disadvantage of seeking to vacate a judgment on the grounds of improper service is that you have the burden of proving the bad service, which you must do at a special hearing called a traverse hearing. Proving improper service can be difficult depending on the facts of your case. How do I vacate a judgment? First, find out which court issued the judgment. In a debt collection case, you will most likely need to go to the civil court in the county where you live. Next, go to the court that issued the judgment and find the civil court clerk's office. There, tell the clerk that you want to file a, quote, order to show cause. The clerk will give you a pre-printed form to fill out. Or you can go to their website if you call them. If you Google, if you go on their website, you can look at the copy of the form here. Clerk can also help you fill out the order to show cause form. The New York State Office of Court Administration has produced an interactive online program that can also assist you in completing your order to show cause form. You may access the online program here. Look for affidavit to vacate a default judgment in a consumer debt case. So as you can see, there are a lot of websites that teach you exactly what to do, and you don't necessarily need to spend thousands of dollars and go run to an attorney if you don't want to. On the order to show cause form, you need to explain why the court should vacate the judgment. In other words, you have to establish either excusable default or lack of jurisdiction, or both. We recommend that you always include on the form A, the reason why you did not appear in court, and 2, a meritorious defense. If you need help deciding what to write on the order to show cause, please call the New York City Financial Justice Hotline. There's like a New York City free hotline that'll help you. Interesting. No, you're right. Sometimes the court clerk will tell you not to say that you did not receive a summons. The, quote, advice is improper. You have the right to challenge improper service, and in fact, improper service is often at the root of a default judgment. If you were not properly served, you should always say so in your order to show cause. Should I write anything else on my order to show cause? If you have a frozen bank account that contains exempt funds, if your wages are being garnished, or if there is any other emergency situation requiring that your judgment be vacated more quickly than usual, you should include this information on your order to show cause. What happens after I fill out an order to show cause? After you fill out an order to show cause form, it goes to a judge for signature. In Brooklyn, Kings County, you will take it up to the judge yourself. In all other counties, the court staff will take it for you. In both cases, you have to wait to find out whether the judge signs it. If the judge signs your order to show cause, you will have to serve it on the attorney for the plaintiff. The court will instruct you on how to serve the papers. The court will also give you a date to come back to court, your, quote, return date. The return date is supposed to be within 8 days of your order to show cause, but in some courts, you might have to wait 2 or 3 weeks for a return date. Therefore, it is an emergency situation. You cannot wait 2 or 3 weeks to see a judge. You should advise the court of this fact at the time you submit your order to show cause. If the judge does not sign the order to show cause, then the judgment stays in place. Don't despair. Call the New York City Financial Justice Hotline for advice. Next. What happens at the return date? At the return date, you will most likely find yourself sitting in a courtroom with a number of other people who are in the same position as you. The court clerk will call out your name, and you should answer clearly. The attorney for the plaintiff may call out your name as well. The plaintiff's attorney might consent to your order to show cause or ask whether you want to make a settlement agreement. No matter what the plaintiff's attorney says to you, it is important that you focus on making sure that the default judgment is vacated. If the plaintiff's attorney does not consent to vacating the judgment, you should ask to go before the judge. When you are before the judge, you must focus on the arguments you made on the order to show cause form. Simply keep repeating 1, your good reason for failing to appear in court, and 2, your defense in your case. As long as you have a reasonable excuse and a meritorious defense, the judge should grant the order to show cause and vacate the judgment against you. If you want to argue lack of jurisdiction because you were not served the summons, you must ask the judge for a traverse hearing. Okay, what if I have a frozen bank account or wage garnishment? Once the default judgment is vacated, the plaintiff must release your bank account and cancel the wage garnishment. This is included in the court's order vacating the judgment. If the judgment is vacated, does that mean the case is over? Probably not. In most cases, even though the judgment is vacated, you still have to defend the case. This means that you have to file an answer and attend at least one additional cut date. More information: the basics of defending creditor lawsuits, how to read a civil court summons, the preparing for your court date, negotiating a settlement agreement in court, force bank accounts, wage garnishment, what is exempt from debt collection, yada yada yada. So interesting website. I'm not either endorsing nor not endorsing the hotline or any of the stuff that they call, but it's interesting what you can find on Google. I will put some other related videos on YouTube. Thanks for watching. And make sure to check out Understand Contract Law and YouWin.com, because we have a lot of inside the box and outside the box remedies for different people. You can click off here, I have credit card debt, fill out your name, information, and click submit, and you will be contacted by somebody at some point relatively soon, and we help people with a bunch of different things here. It's not legal advice, but generic information that kind of like what we found on Google, maybe just some information shortening your learning curve, leading in the right direction, or directing you or sending to you specific things that you may find helpful for your education process, whatever. So make sure to check out our site. Okay, bye.